course of this module and the next module, we will look at the Right to Information Act as also the Central Information Commission and State Information Commissions. In this module, we will first take up the Right to Information Act. What are the various provisions of this RTI Act? What is information? Who can seek it and from whom it can be sought? And what is the time frame for giving this information? How does this right to information affect the enjoyment of human rights? These are some of the things we will look at in this module. Article 19 of the Universal Declaration of Human Rights that was adopted in the year 1948, and also Article 19 of the International Covenant on Civil and Political Rights of 1966 both assert the right of every citizen to seek, receive and impart information and ideas. And if you look at our own constitution, which was drafted around the same time as the UDHR, Article 19(1)(a) upholds, asserts or guarantees freedom of speech and expression. And to give effect to this right to freedom of speech and expression, RTI Act was enacted in the year 2005, and it replaced the Freedom of Information Act of 2002. And how does it affect human rights? For instance, corruption impedes the enjoyment of civil, political as well as economic, social, cultural rights. The right to information is a powerful tool in the hands of the general public in order to have a corruption-free administration, in order to have access to critical information for the enjoyment of their rights, including right to food, education, health, social security, and many other rights. In this manner, right to information acts as an enabler to realize other human rights. RTI Act basically empowers a citizen to seek information from a public authority, and the information can be of diverse kinds, and the RTI Act itself defines information in a very expansive manner, and through this the person can hold the government accountable, can hold the administration accountable. In fact, there was a civil society movement in Rajasthan which was started by Kisan Mazdoor Shakti Sangathan, and which really asked for muster rolls for rural employment programs, poverty alleviation programs, and unearthed corruption, and they held a Jan Sunvoice, and it was this movement which really resulted in the enactment of the Right to Information Act, and under which there is a central commission and there are state information commissions. And if you look at the section 22 of the Right to Information Act, the RTI Act has a overriding provision wherever there is a conflict between RTI Act on the one hand and other laws, say like Official Secrets Act. In fact, the adoption of the RTI Act represents a paradigm shift from an era or a regime governed by under the Official Secrets Act to a transition to a era or a regime governed by transparency and accountability. Sections 2 of the RTI Act contains definitions, and the word information has been defined. This information means material of any kind, may include documents, records, file notings, logbooks, contracts, or material held in any electronic form, and many other things like maps, photographs, and so on and so forth. And here is the definition of what constitutes information. And Supreme Court of India, in a particular case involving Central Board of Secondary Education on the one hand and Aditya Bandyopadhyay on the other, made a distinction between three different categories of information. They said on the first category, here is a information which is held by a public authority, which is of critical importance to the citizen, and which will non-disclosure of which may affect the transparency, or it may affect corruption. On the other hand, there is a category B which talks about information held by a public authority, which is not covered by category A. And then the third category contains information which is not held by a public authority, or which is not collected by a public authority. The Supreme Court said both in terms of first and second categories, the information should be supplied to the citizen when asked for. In particular, as regards the first category, information which disclosure of which can fight against corruption, fight against non-transparency, the court said the public authorities have a duty suo motu to disclose that information. They have a duty to, under Section 4 of the RTI Act, proactive disclosure through their websites and other modes. As regards second category, a person can file an RTI query and seek that information. As regards the third category, that is namely the information that is not held or collected by a public authority, the court said this is not covered under the ambit of the Right to Information Act. Under Section 6 of the RTI Act, any person can seek information from a public authority. He need not give any reasons why he or she is seeking a particular information, and no personal details need be given while seeking information, excepting the contact details which are required for supply of the information. In other words, the RTI Act has not prescribed any specific pro forma or a format for seeking information under Section 6 of the Act. The only thing is that it should fall under the ambit of the Act, and in where there is a dispute whether certain thing falls under the ambit of the Act or not, it is the courts which eventually decide whether it does or it doesn't. A person seeking information has to pay a modest or a very, very small fee prescribed under the Act while seeking information. In fact, we have seen already the definition of information, which covers a wide range of things, including records, documents, orders, etc. A citizen has a right to seek information on orders, etc., but he cannot ask why such orders have been passed by authorities, especially the judicial authorities. Now let us turn our attention as to who is a public authority. In fact, the central government, the state governments, or any body which has been established under the Constitution of India, or any legislation passed by the by the parliament or the legislature is a public authority. In fact, units which are owned, bodies which are owned, controlled, or substantially funded by a central government or a state government are also regarded as public authorities. Non-governmental organizations which are substantially funded by the government are also regarded as public authorities. In fact, one can seek information from them under the Right to Information Act. In fact, every public authority is required to designate public information officers and also other officers to receive appeals against the decisions of the public information officers. This, when a citizen files an application or an RTI query asking for information, there are only two courses of option which are open to the public information officers. They can, in case the information exists and in case the information is held by that particular public authority, the public information officer is expected to accept the application and provide that information. And the second option is that in case the information is not held by that authority, in case if the information is not covered under the RTI Act, the public information officer can reject such application. So either of which should be done within a time span of 30 days from the date of application. There are several exemptions for furnishing of information which are provided under section 8, 1 and 9 of the RTI Act. They exempt public authorities from disclosure of certain information under certain reasons. In fact, I draw your attention to the following graphic, and please pay close attention to the graphic to know the exceptions to the disclosure of information. For instance, the section 8 prescribes the following grounds for rejecting a person's request for disclosure of information if it pertains to national security or sovereignty and integrity of the nation, national economic interests, relations with foreign states, law enforcement under the judicial process, information available to a person in one's fiduciary relationship, cabinet papers and other decision-making documents, trade secrets, intellectual property and commercial confidentiality, individual safety, personal privacy. In fact, the following three grounds of rejection can be cited by the public information officer under public interests: trade secrets, intellectual property and commercial confidentiality, information available to a person in one's fiduciary relationship, personal privacy. Section 9 allows the rejection of a request for disclosure of information that would involve the infringement of a copyright subsisting in a person other than the state. Dear students, we saw in the earlier graphic the items which were exempt from disclosure under section 8(1) of the RTI Act. In fact, the Act also provides that after a lapse of 20 years after the incident to which the information relates, these items will be exempt from what you call the operation of this non-disclosure. In fact, so there is a 20-year time limit provided under the Act after which they cease to be exempt from disclosure, except in a few cases. What are those cases? For instance, if there is information which relates to the sovereignty and integrity of India, or it relates to the strategic or economic interests of the state, or it relates to the maintenance of friendly relationship with other countries, or secondly, if there is any information the disclosure of which constitutes a breach of privilege of Parliament or the state legislature, and information relating to Union Cabinet decisions or State Cabinet decisions or meeting of the committees of secretaries, these will, however, continue to be exempt from disclosure even after a lapse of 20 years. Now, if you look at section 24 of the RTI Act, information relating to intelligence wing of the state or some security organizations have been exempted from the purview of this RTI Act, and these list of such organizations are specified in the second schedule to the RTI Act, and the union government and the state governments are empowered to amend this list from time to time. I draw your attention to the following graphic, which talks about various authorities under the Act and the time frame for entertaining or disposing of the first query under the RTI Act, or details for entertaining the first appeal and the second appeal. In addition, if you look at RTI Act, there are detailed provisions relating to the constitution, functions and powers of the Central Information Commission, State Information Commissions, which are mentioned, and in fact in the coming module we will look at the operation of this Central Information Commission in greater detail. Thank you. See you in the next module.